So you got an office action asking you to disclaim a term, or you got a call from the examining attorney asking you to disclaim a term. Stay tuned to find out what that means. What is a disclaimer? The USPTO may ask you to disclaim certain wording in your mark if it merely describes an ingredient, quality, characteristic, function, feature, purpose, or use of applicant's goods and/or services. One example can be the entity designation. If your mark is arbitrary company, you will likely have to disclaim the word company. The language of the disclaimer would say something like, "No claim is made to the exclusive right to use company apart from the mark as shown." In other words, you would be able to enforce your arbitrary company mark, but you could not stop someone else from using company by itself. Some other examples of words that may need to be disclaimed include conference, hotel, restaurant, school, etc. It wouldn't be particularly strong, but sometimes you may want to just protect your logo or stylized lettering. For example, there are registrations for stylized juice bar and tropical juice bar, with both disclaiming the word elements of the marks. The protection of each respective mark is in the exact representation of the logo only because the words are generic. You can make a disclaimer in your application, but you can also wait until the examining attorney examines your application. Typically, if that's the only issue they find in the application, they may call you to see if you'd agree to an examiner's amendment without them having to issue a formal office action. There may be times that you will want to push back on the examiner asking to make your disclaimer, so be sure to talk to your trademark attorney about that. One thing I'm not disclaiming is that trademarks are fun.